Welcome back, and welcome to Unit 2, where we're going to dive into wills. Over this unit, our goal is to help you understand what wills do, how to read them, and how to make sense of the ideas and language you'll see inside them, without needing a law degree to follow along. In this lesson, we're starting with the big picture. We're talking about where a will fits into an estate plan, why it matters even if your life feels simple right now, and how it works alongside things like trusts, beneficiary designations, and probate. So far, we've gathered the facts of what you own and who and what you care about. Now, it's time to start looking at the tools that put those facts into action. Today, we are starting with the most well-known tool in the kit, the will. Here's why wills matter. Many people assume a will controls everything they own. Others assume they don't need one because they've named beneficiaries or heard trusts are better. Both ideas miss the real value of a will. A will isn't about complexity, it's about direction. It's often the document that steps in when something unexpected happens, or when another part of a plan doesn't work as intended. At a basic level, a will is a written document that explains how certain property you own could be handled after your death. That property is usually part of what's called your probate estate, meaning assets that don't automatically transfer to someone else by title or beneficiary designation. A will also commonly names key people, like the executor, who helps carry out the instructions in the document. A will may also help express personal priorities. Most importantly, for those of you with young families, a will is the only place where you can legally name a guardian for your minor children. This is perhaps its most vital role, ensuring that if the unthinkable happens, you have already decided who is best suited to raise your children and manage their care. One important thing to understand early is that a will doesn't control everything. Some assets pass outside of the will entirely. For example, accounts with named beneficiaries, jointly owned property with survivorship rights, and many retirement accounts usually transfer automatically. That's why estate planning often involves both a will and a review of beneficiary designations. These tools work alongside each other, not in competition. This brings us to probate. Probate is a court-supervised process that helps settle the probate estate and confirm instructions in a will. The process varies by state and by situation. Some estates move through it quickly, others take longer. The key takeaway here isn't speed or cost, it's that probate is the mechanism through which a will is carried out. Think of probate as the script, or the court-supervised process that proves your will is valid and ensures your debts are paid, correct beneficiaries receive their inheritance, and your wishes are carried out. While some tools, like trusts, are designed to help assets skip the probate process, your will is the essential document that guides the court on what you want done with everything else. It's important to understand that your will only controls your probate assets, the things you own alone that don't have a specific beneficiary named. Even well-organized plans sometimes miss an asset or experience a change that wasn't updated in time. A will may provide backup instructions so those assets don't fall into uncertainty. Think of it as the document that catches what might otherwise slip through the cracks. Now, let's clear up a common question. Is a will the same thing as a trust? The simplest way to remember the difference is timing. A will generally only takes effect after your death. A trust, which we will explore later, is like a container that can manage your assets while you are still alive and even after you're gone. Neither tool replaces the other automatically. In many plans, they work together. In others, a will alone may cover the essentials. Let's look at a simple story. Imagine someone who carefully named beneficiaries on accounts but never created a will. Most assets transferred smoothly, but one account didn't have a beneficiary listed. Without a will, that account followed default state rules instead of personal wishes. The issue wasn't lack of care, it was lack of a backup plan. Now imagine someone with a simple will in place. Even though their plan wasn't complex, the will provided instructions for anything unexpected. Their executor knew where to start, and their family didn't have to guess. The will didn't do everything, but it did its job. Here's the perspective shift that matters most. A will isn't about predicting every future detail, it's about creating a clear starting point. It gives structure to the process and helps other tools work more effectively together. If you've only watched this video, you've already gained something valuable. You could now explain what a will generally does, how it connects to probate, and why it still matters, even alongside other planning tools. That understanding alone puts you ahead of where many people are. Now for a small action you can take today. Begin thinking through the following questions. First, whether you currently have a will, if you know where it is located, and if it is currently updated. Second, who would you like to serve as your executor to work with the court to settle your estate? And finally, who are individuals you may want to include as beneficiaries of your estate? If you'd like to go deeper, optional resources are available that help you list assets, review beneficiary designations, and compare wills and trusts at a high level. These are there to support you, not to pressure you. As we move forward, the next lesson will zoom in specifically on what a will can and can't do, and the laws that regulate wills. For now, you've laid the foundation. And foundations matter, because everything else builds on them.